Hello and welcome to our Freebie Friday video. Sade here. Today's question was sent in asking about the mechanic's lien and what are the implications of the mechanic's lien to a homeowner or somebody that owns commercial property, for instance. So I will speak from the perspective of the property owner, but this might be helpful also for contractors to and tradespeople that work on construction projects or remodeling. The mechanic's lien is also called the material man's liens. People that work, as I said, on construction, whether it's building a brand new commercial property, residential property, or even just helping in the process of getting ready to design the project, they are all considered tradespeople or material men, which I don't quite understand that terminology, but they provide materials. Sometimes they provide their knowledge. So this covers people like plumbers, electricians, general contractors, all the subcontractors. It could be people that are painting the walls. It could be people that are laying the shingles on the roofs. And it could also be the surveyor that's drawing up the plan, the architects that are drawing up the plan, the surveyors that's taking the survey of the property. It could be people working on fences. Could be just even the rental equipment that's brought in to help with the building of the home or building of that commercial project. It also covers remodeling and repairs, of course. So the materials lien and material men's lien or mechanics lien, as you can hear the word lien, the lien just means almost like an indebtedness. So it's something that attaches to real estate. Usually it would attach to human beings sometimes, but in this case, that lien attaches to the property that the people put all their effort and labor into it and the materials that they provided. So it's almost a way to guarantee that they get paid. It's not 100% of a guarantee, but it helps them in enforcing their rights to collect for work or effort or labor that they provided, or even the materials. So that's really the short summary on what the material men's lien is, or the mechanics lien is what most people call it. And the reason why the Texas Constitution actually put something in place is because homeowners would have people work on their homes, and it's very difficult to collect after you've already painted a wall. You couldn't really unpaint a wall once you've already done it. You can't really demolish a wall once you've already put it up. And so most of these people that are working to help people to build their homes or repair and remodel, they were being duped by the homeowners. And the Constitution said, wait a minute, we need to do something about this to help these people collect on their effort and labor that they put in, as well as the materials that they used. And so that's what the history is all about as far as the mechanics lien. What is the effect of the lien and how does it work? So it can be used as a general contractor. It can also be used by the contractor, as I said, and also all the other parties that are involved could potentially put a lien against the actual property where they provided work. And it is provided for under the Constitution and also under the Texas Property Code by statute. So there's several provisions that need to be followed, but the general idea, so that for the purposes of this short educational video, would be that the homeowner needs to make sure that the general contractor is paying all the subcontractors if that's the agreement, and also request that all notices for non-payment be made known to you as the homeowner or the commercial property owner, so that you know what's going on, what's being paid, what's not. As long as you're paying the general contractor is supposed to be paying the subcontractors. Some homeowners do it in a different way where they're in charge of paying everyone, so just make sure you're paying everyone on time. The law requires them to give you a notice before they ever file the lien. Some of them will go ahead and file the lien without the proper notices sent out, but typically they'll give you a disclosure while entering into the contract to begin with. So the general contractors have on their forms, the ones that are very organized and professional about it, they'll have a disclosure warning you that you could potentially have an issue with the mechanics lien as a homeowner if you don't pay all the bills as agreed once they've performed substantially. That's the requirement under the law, is that they've almost completed the work. So they've done a good chunk of it. And if they're not able to complete the work or do a good chunk of it, and maybe it's because the homeowner said that they shouldn't come back, or the homeowner ran out of money or abandoned the project, as long as they substantially completed the part that the stage where they are, then they're eligible to file this lien. And so that they'll give you that disclosure, and then after the work has already been done, they still have to provide a notice of non-payment and a homestead warning if the property is a homestead. But most of them typically just provide those notices together to let you know, hey, I haven't been able to collect my money from the general contractor. I'm just letting you know that. And if I still don't have my money in X number of days, I might have to file a lien against your property as the homeowner. What that does is it motivates the homeowner to look into it and make sure that the subcontractor gets paid. If it's the general contractor that files the lien, the same thing. The homeowner is threatened by that lien because the effect of the lien is it shows up in the public records in that county, and it puts a cloud on the title to the home, because the homeowner is going to have problems with trying to sell it or refinance once that lien shows up. The other effect that the lien has, and this is probably what is most scary, is that the mechanic's lien holder, the creditor, the subcontractor, contractor, whoever that is, the architect that filed that lien, they have the power to foreclose on that property within a certain number of years. And it's usually 1 year for residential property and 2 years for commercial property. Sometimes it's 2 years. So all of that is very technical and very specifically outlined in the statute. So you probably need a lawyer to look into that for you if you're the homeowner or even the contractor trying to file the lien. It has very specific requirements to make sure that that lien is filed properly so that it's not invalidated or challenged in the future. Usually 2 years maximum to be able to do the foreclosure. If the lien holder, who is that tradesperson, doesn't do the foreclosure within the 2 years, then the homeowner can actually request that the lien be released. The other way to release the lien would be to just pay that subcontractor or contractor, or negotiate some sort of settlement. Either way, there has to be a release of lien filed, the mechanic's lien. So I hope this video has been helpful to you. If you have any other questions about this, feel free to email us or call us, and we'll be happy to cover that as well. And we'll do another video that would help the subcontractors and the contractors kind of know how the steps to filing that lien in Texas. All right, we'll talk to you next time. Happy Friday.